Hello friends, in the series on the income tax cases, today we will discuss the case related to section 234E. As all we know that section 234E talks about the late fees which is to be paid for filing tedious returns rate if the tedious returns are not filed as per the time prescribed in section 200 subsection 3 or proviso to section 206C subsection 3. Section 234E was introduced on 1st July 2012, but the amount of fees was introduced with effect from 1st June 2015 according to section 200A subsection 1 clause C. As far as the tedious returns which were late after 1st June 2015, there is no doubt the late fees is to be deposited by the assessee. But for the period from 1st July 2012 on which section 234E came and 1st June 2015 on which the amount was specified of 200 in section 200A subsection 1 clause C. As far as that period was concerned, this case is related whether the fees is to be paid for that period also or not. This issue has been taken by the Madras High Court in the case of Conceria International Private Limited versus Income Tax Officer and another, and this case has been reported in 464 ITR at page number 92 and the date of the judgment is 10th November 2023. The case relates to the assessment year 2010-11 to 2015-16. Section 234E says that the late fees is to be paid by the assessee if the tedious statements are not submitted according to the time limits which are given in section 200 subsection 3. Now after that, on 1st June 2015, section 200A subsection 1 clause C was amended and it was amended with effect from 1st June 2015 specifying the amount of rupees 200. As far as the dispute, after 1st June 2015 there is no dispute. If the tedious statements are submitted late, the late fees of 200 per day is to be deposited by the assessee. As far as the period from 1st July 2012 to 1st June 2015 is concerned, the assessee was taking the plea that although section 234E came from 1st July 2012, but because section 200A subsection 1 clause C was amended with 1st June 2015, which talks about the recovery mechanism of that fees, so the late fees should not be payable by the assessee from 1st July 2012 to 1st June 2015. Some courts have given favor to the assessee, but in the present case, the Madras High Court was of the view that section 234E creates a liability and the liability to pay late fees is not dependent on section 200A subsection 1 clause C, which only prescribes the recovery mechanism and reflects the true intent and purpose of section 234E. So, the Madras High Court is of the view that the assessee has to pay and is also liable for the late fees for the returns which have been deposited late in the period 1st July 2012 to 1st June 2015, irrespective that section 200A subsection 1 clause C has been amended with 1st June 2015. Friends, this case is very important because there are contradictory decisions by the various courts regarding this. So it depends upon the case of the assessee. If the jurisdictional High Court is saying in favor of the assessee can take the benefit of that. But now the Madras High Court has now gone against the assessee in the present case. At the end of this video, once again, I am repeating the name of the case. The name of the case is Conceria International Private Limited versus Income Tax Officer and another. And this case has been reported in 464 ITR, page number 92. And the matter has been decided by Madras High Court and the date of the judgment is 10th November 2023.